Okay guys, we're going into a deep dive regarding the fabricated bogus order to falsely imprison me, all because I'm reporting the information on this Instagram account. Before we do a deep dive into the bogus order, here's an introduction to the situation. A court is there to be an unbiased mediator where people receive due process, such as having your reasonable questions answered, in return answer reasonable questions, and face your accuser. You would think if an individual has an order placed against them, they must have had a chance to plead their case and defend the accusations. But not in my case. To be clear, I have not had one day in court and they have already placed orders against me. I've never received a statement of claim with my name as the defendant, so how is this possible? To receive due process in Canada, you should have been served a statement of claim allowing 20 days to respond with my defense. Then we schedule a mediation conference. Then if mediation fails, we move to trial where all sides present their case via evidence, where each side has a chance to scrutinize each other's evidence. This due process can last from 6 months to 2 years. They sent me an order without doing any of this the same day. Now, the reason I did not get a statement of claim served to me is because no member of the public is upset with me regarding my investigative reporting or any other reason. So who is upset with me is not the public. It seems that it's unethical bank lawyers and a corrupt judge are the ones who are upset and are abusing the process to stop me from reporting to the public on their very unethical, bordering criminal actions, attempting to falsely imprison a Canadian, me. As you can see, the memorandum process is being completely abused, which is called abuse of process. The culprit is Judge Neilson and 3 unethical Alberta bank lawyers. Now, it gets worse, but more interesting. On May 30th, 2024, just 6 days after Judge Neilson created the bogus order, Capital One lawyer Keith Marlowe, who requested to have a statement of claim struck regarding Kerslake versus Capital One, due to it having OPCA traits. Judge Neilson denied the request because he said it did not have OPCA traits, but in the memorandum order, he says the exact opposite about the exact same court file, contradicting himself. We have the documents with voiceover where he clearly states it is not OPCA. Here are the AVAC documents and Judge Neilson's response. This is a very important part of the puzzle to understand because Judge Neilson totally contradicts himself when comparing to what he says in the order regarding Kerslake versus Capital One. Okay guys, so here is the order that has my name on it, and this is from a Judge KG Neilson. Now, before we go into a deep dive into this order, what we're going to do is introduce you to these 3 documents that are going to together completely have Mr. Judge Neilson contradict himself in each of the order and his decision. Literally 90% of each of these, the decision and the actual order that Judge Neilson made, is going to be in contradiction to these 3 documents. So let's take a look at these 3 documents. So there is a gentleman by the name of Terry Kershaw against Capital One. He put in a statement of claim stating that he's asking for proof of ownership of the debt because there's a private lender, and together they're asking for proof of ownership of the debt to make sure the bank did not sell it. So let's take a look at what Keith said here.
I have reviewed the statement of claim. It appears on its face to be frivolous, vexatious, or an abusive process. Specifically, it appears to use organized pseudo-legal commercial argument techniques, i.e. demanding that the other side prove its authority and asserting a unilateral agreement. See Meads v. Meads, 2012 ABQB 571. In coming to this conclusion, I note that I have not considered the email submitted by counsel for the defendant, because no evidence is allowed as part of a request for a CPN 7 review. See De Medici v. Wawanesa Mutual Insurance Company, 2023 ABKB 210 at para 37.
The claim in question is not vexatious nor frivolous due to the following underlying facts. On March 7, 2023, Terry Kerslake arranged private financing to pay his debt with Capital One in full. Within the Capital One loan agreement, Capital One states very clearly they may sell their rights to the agreement without informing the borrower. This can be found in the assignment clause, which reads, 24. Assigning your account. At any time, we may sell, transfer, or assign any or all of our rights and obligations under this agreement or your account without telling you in advance. Due to the assignment clause being present in the agreement and the fact debts are bought and sold via the process of securitization, every day within the finance industry, Terry made one reasonable payout condition for Capital One to fulfill in order to receive the entire amount they claimed was owed to them. Terry had simply requested Capital One provide him with verifiable proof they still maintained ownership of the rights to his contract by simply having a chartered accountant provide an affidavit that states they have checked the ledgers and can confirm Capital One maintains ownership of the rights to Terry's loan agreement. Due to the fact a chartered accountant would be the only entity with access to the ledgers to see the information needed to make that claim, who would not be in a conflict of interest when doing so. Please note, the Canadian Rules of Court is very clear that verifiable proof of ownership is a sworn affidavit from a chartered accountant stating he looked into the ledgers and the debt was not sold. The reason the court has this rule is because a chartered accountant is the only one who has access to the ledgers to make that claim. And furthermore, chartered accountants are governed by a third party who will take away their license if reporting false information. The above request should be very simple to fulfill, due to the fact the defendant stated they could transfer, sell, or assign their rights at any time without informing the plaintiff in advance within the agreement. This is a very reasonable request. The defendant has also failed to deem the request as unreasonable or to explain exactly why Capital One would be unable to have a chartered accountant validate the debt. It is common sense that an entity cannot collect money for assets which they do not own. This would be considered misrepresentation of the facts leading to fraud. To claim verifying ownership of an asset before a transfer of funds is vexatious, or a pseudo-law concept is ridiculous. Terry suffered damages when Capital One made false or misleading credit reports, as defined by the Consumer Protection Act of Canada, while he was in the middle of conveyancing and attempting to pay them out in full. Why would the plaintiff or anyone keep making payments when they have served them reasonable conveyance conditions and have proven funds to pay the defendant out in full? But it is the defendant who cannot produce proof of ownership, documentation they are legally obligated to produce for months. We have put the defense to the task of explaining exactly where drawing comparisons between Kerslake versus Capital One and Meads versus Meads. Seeing as Meads versus Meads does not involve a bank nor a private lender attempting to pay out the debt in full, we fail to see any parallel between the two cases. The defense has also failed to bring any parallels to our attention. This is a very straightforward business transaction. This is a private lender, not a financial institution, supplying the funds, and this is where the defense arguments start to come apart. When a financial institution forwards money to another financial institution, this is considered an internal transaction due to the fact they are all part of the central banking system. But when a private lender is forwarding funds to a financial institution, it would be considered an external transaction. Therefore, in each situation, there are different conveyance conditions that the defense is not aware of or ignoring. The banks, via credit cards, have been charging large compound interest rates to the Canadian public over the past 2 decades, that now the Canadian public is naturally turning to private lenders due to lower rates and easy access via the internet. These Canadian private lenders are just average people who have extra money to invest, so obviously they want to complete their due diligence and verify they are handing their money to the right entity. For example, if you were buying a car from someone, but when asked to see proof of ownership of the vehicle, and they said, "I don't have it on me right now, but give me the money anyway," who in their right mind would hand the money over? Furthermore, a Canadian borrower went into the marketplace to find a lender who can provide better rates. The Canadian private lender advertised better rates than bank credit cards for borrowers. These two parties have every right to participate in the contract. Considering the 2008 financial crash, the banks openly admitted the reason for the crash was because they were selling the debt irresponsibly to the world market. Due to this fact, private lenders have started exercising their right to obtain verifiable proof of ownership from not only other private lenders, but also the bank which they are legally entitled to do so. In conclusion, Terry's single payout condition was reasonable, as Capital One may no longer own the rights to the contract which they are attempting to act on, as well as the fact Terry genuinely suffered damages due to the false or misleading credit reporting committed by Capital One while he awaited his reasonable payout condition to be met. Terry is still willing to pay Capital One in full should they decide to provide the requested affidavit. If Capital One did sell the debt, Terry simply asks that Capital One inform him of whom the debt was sold so he may continue this transaction with the rightful owner of his debt. Terry simply asks that Capital One correct the false or misleading credit reports while he awaits the reasonable payout condition to be fulfilled. Terry awaits the defendant to answer the following reasonable questions. If you believe the payout condition to be unreasonable, can you please deem it as so and explain exactly why? In detail, what are the parallels the defense is drawing from to make this unreasonable comparison of the two cases he chose listed above? Is the defense aware of the fact banks can sell a debt days after the contract was signed via a process called securitization?
On November 30, 2023, the plaintiff filed a statement of claim. On February 21, 2024, counsel for the defendant asked the court to review the statement of claim under Civil Practice Note 7, CPN, because it allegedly contains pseudo-law concepts. I have reviewed statement of claim in light of the plaintiff's written submission and the defendant's written reply. I conclude that it is unnecessary to invoke the abridged procedures under CPN 7 in this case. C. DeMedici v. Wawanisa Mutual Insurance Company, 2023 ABKB 210 at para 28.
Now that you've seen the AVAC response, you will now clearly see how bogus this order really is. Fabricated solely to falsely imprison a Canadian journalist, me. Due to Judge Neilson's AVAC response, this order has already been 90% proven wrong due to the fact anywhere it tries to lump these court files in with OPC in the bogus order is null and void, considering Judge Neilson has completely disproven himself. Let's take a look at this. Okay guys, here is the bogus memorandum decision of Associate Chief Justice K.G. Neilson. Okay guys, so remember, we've done most of deep dive now because we've seen that in his HVAC response, it came down to this exact file, which is placed right here, this case, Kerslick and Capital One Bank versus Capital One. Now, you see, Kerslick versus Capital One Bank, this is the exact response that he said that no, it is not OPCA, but here he says it is OPCA. There is no reasoning here. It contradicts everything, and 90% of this order and decision has been already disproven because he is mentioning OPCA and all the rest of it. Look, he has a whole heading OPCA arguments, but he's already proven that it's simply not OPCA because he's contradicting himself because he's using the same case file to say the exact opposite things, okay? At the end of it, this is what's really happened is that they're just trying to muddy the waters. How did it get from the point of a Canadian with a private lender asking for proof of ownership of the debt from the bank, plain and simple, all of a sudden 9 months later resurrect the file and say that, oh, we're putting an order against Kevin Kumar because of what? Illegal representation? That is absolutely insane. But anyways, as we take a look at this and we realize that anywhere it says OPCA versus Meads or anything like this, OPCA, it is absolutely null and void. OPC arguments again. He himself said that Kerslake right here was not OPCA, and then he's saying it is OPCA. All of this is null and void. Everything he's put underneath OPCA arguments because of the HVAC response that he sent to Keith Marlowe saying that no, this file right here, Kerslak versus Capital One Bank, is not OPCA, but it says here OPCA. Now, all that is null and void then, okay? That's very, very simple way to go about this, okay? Now, it comes into where it says Kevin Kumar. So guys, they take this whole decision about slandering me. All of this, everything they've placed here was made up in a memorandum the same way. I wasn't tried for it, nothing. They just made it up in a memorandum because I sued the Alberta judges. I organized many groups to sue them for wrongful foreclosure and negligence in the workplace. So it's 2024 now. These are all the lies here that they're bringing up from 2014. Again, it was a memorandum. I didn't get any say in it. They just made it all up and put it down and said, look at that, and took away my due process because they're the judges and we sued them. Okay. Now, of course, it's pretty naive to sue judges, but at the time, we just thought that was the right thing to do, and that we didn't realize and how corrupt they were, that they were literally going to wrongfully imprison us, right? So this is just them slandering me, and we're going to do a show on this on itself, okay? So what is their bogus claim in order to shut me up from sharing this information or put me in jail? It states I'm acting as a legal counsel. What is their alleged proof in the bogus order decision that I am? First of all, they say I appeared as a support person for a case, which I did. But there was no foul because the judge acting over the case gave me permission to do so as a support person, not legal counsel. I appeared via speakerphone and the judge gave me permission to state some obvious facts regarding a statement from a bank is not verifiable proof. They still own the debt. The judge's argument was weak, which I disclaimed, and we have transcript to prove it. Judge Neilson mentions to further slander me that at the hearing I was aggressive, but I made it through the whole trial without getting muted. So obviously I was not aggressive and conducted myself to the court's satisfaction. Judge Neilson is claiming illegal representation, but obviously when you get permission from the judge presiding over the trial to speak as a support person, debunks this claim completely. This is a bogus order completely. They also said that I created legal documents and filed them for another, which I did not. But more importantly, what proof do they have to make this claim? Do they have video surveillance showing me going into the court to file any papers? No, they don't, because I did not fill out any legal documents and file them on behalf of anyone. Where is my due process? I'm simply an investigative reporter. So they have no proof of this or any other of their accusations in the order and decision, but they still place an order against me? Once again, where's my due process? And this is completely abusive process in order to falsely imprison me if I don't stop sharing the information via social media. They have emails from UnitedWeStandPeople.com stating very simple requests on behalf of the client, sending it to the lawyer. The client asked us to act as their chosen agent, given us written authorization to do so. The RBC lawyer did not want to answer any questions via UnitedWeStandPeople.com due to the fact that we're not legal counsel. We backed down and started to come from an investigative reporter, public watchdog approach. We explained to the defendant, the Canadian borrower, that he will need to communicate directly with the lawyer and we will report her unethical actions to the public as investigative reporters. The defendant agreed and sent an email with very reasonable questions to the RBC lawyer, such as, are you aware debts are bought and sold? The Canadian sent many other emails, but Melanie Dehaney, the unethical lawyer, absolutely refused to communicate with him. Now the bank lawyer, Melanie Dehaney, has no excuse not to answer simple questions due to the fact it is the defendant, the affected party himself, asking the questions. But Melanie still refused to answer any reasonable questions. Furthermore, Melanie actually did not place her name on the statement of claim. What lawyer does not place her name when filing court documents? Very sketchy. As an investigative reporter who investigates the banks taking away the due process from the Canadian people, I now have a story to investigate and report to the public, which is not against the law or any rules, etc. Furthermore, Judge Neilson provided a snapshot of UnitedWeStandPeople.com website as evidence, but our website and videos state that we are investigative reporters investigating the unethical bank lawyers and judges taking away the due process from the Canadian people. It definitely does not say that we will be your legal rep in court and fill out legal documentation and file it for you. When the unethical bank lawyer and judge saw I was taking a stand for the Canadian people, reporting their daily unethical activities, is when the unethical bank lawyers and Judge Neilson hatched a plan to stop freedom of speech by stopping legal ethical reporting to the public and deemed it as illegal representation, all while threatening to falsely imprison a Canadian, me. But it gets worse. The hearing they referred to was August 29th, 2023, that I appeared as a support person having all permission needed. Then on May 24th, 2024, they pulled this file out after 9 months to attach a memorandum and had an order against me the same day for illegal representation without giving me any due process? What sense does that make when I had full permission to be a support person, but they deem me 9 months later as illegal representation? This makes no sense and is a huge abuse of process. Furthermore, it looks like they are just trying to intimidate me to stop by threatening to wrongfully imprison me. You see, their next step is to simply make up anything pretending that I broke the order so they can falsely imprison me for civil contempt of court. That is exactly what they did in 2016 to wrongfully imprison me then. We chat GTP'd the memorandum process and it came up with some very interesting facts we'll share with you now. Take a look at this. Okay guys, so we're going to show you how bogus this order really is. Now we chat GPT'd what is the purpose of a memorandum decision in Canada. Now, Judge Neilson completely fails the first two with this bogus memorandum decision and order he placed against me, having no proof of me ever filing or acting on behalf of anybody as a legal representative. I am a investigative reporter, okay? So, here we go. It says here, a memorandum decision in Canada serves several key purposes in the judicial process. Efficiency. Memorandum decisions are typically brief and straightforward. Let's stop here, okay? Because he's completely failed that. This is not brief and straightforward in any stretch of the imagination, okay? And it keeps going and going and going, okay? And look at this, guys. I want to show you no appearances. There is no appearances whatsoever, okay? Nobody showed up because nobody was invited. How ridiculous. Now, clarity on rules. These decisions provide a clear statement of the court's ruling and the reasoning behind it, but without extensive legal analysis. Okay, guys, so let's go back to this bogus order again, and you're going to see, we'll go to the top, and you're going to see how many case law he is stating here. All this case law. Oh, this has nothing to do with analysis and all the rest of it. This is insane. All of this needs an actual trial where a person gets served a statement of claim, then they get to send a defense, and then they get to look at each other's evidence and, rebut each other's evidence and all the rest of it. He just placed all this down in a memorandum. This is not straightforward stuff at all, and there's a lot of legal analysis that has gone into this that needs to be rebutted. But either way, what it comes down to is they're just trying to falsely imprison a Canadian here. Now, they already failed that miserably, Judge Neilson, okay? Now, that's what is the purpose of memorandum decision in Canada. Now, we also went and chat GPT'd how can a judge abuse memorandum decisions in Canada. Now, Judge Neilson fits perfectly into every one of these 6 categories that they bring up, okay? So lack of transparency. If a judge consistently uses memorandum decisions for complex or controversial cases, it could lead to a lack of transparency. Detailed written reasons are important for public accountability and understanding the judicial process. So there has been no transparency here because they do not show any proof whatsoever, them saying that I am acting as legal representative people, which I'm not. So the transparency is simply not there. The decision is so long and it's just not a part of what memorandums are for. It's for very straightforward cases. Insufficient reasoning. Memorandum decisions typically contain concise reasoning. If used inappropriately, they may not provide enough detail for the parties to understand the basis for the decision, potentially undermining the party's right to a fair explanation. This is exactly what we're talking about here. Now, they have no proof that I did anything wrong. That's insufficient reasoning as it is. But not to mention that they already said that it was not OPCA in the same case that they brought up in the decision, saying now it is OPCA. There's just no sufficient reasoning in all this, not to mention the fact that I had permission to be acting as a support person from the judge residing over the trial that day. This makes no sense. There's no sufficient reasoning whatsoever. And that's that. Now, let's take a look at avoidance of precedent setting. So this is a very, very obvious one. The banks own the courts when it comes down to it, okay? And avoidance of setting precedents. He does not want to set a precedent that Canadians and private lenders who are handing over their hard-earned money cannot ask the bank for documentation that they're legally obligated to produce, which is proof of ownership of the debt. This is what he's doing here. These are the reasons how a judge can abuse memorandum decisions. We've gone through 3 and he's hit every one of them dead on, okay? Reduced appeal opportunities. Detailed reasons are often necessary for effective appeals. If memorandum decisions are used in cases that should have a full explanation, it might hinder the ability of parties to appeal and the decision properly. So this is exactly this is a whole case in itself. Okay, so yes, it needs to be trialed if they have a problem with me and give me my due process. But what it comes down to it is that they do not give any effective or full explanations, and this is what they're doing, is they are hindering the ability of me to appeal the decision properly. This is what they're doing with this whole memorandum. They gave me no due process. Perception of biases or lack of effort. Now this one is very, very obvious. Over-reliance on memorandum decisions could create a perception that a judge is not giving due consideration to each case, potentially leading to concerns about bias or lack of judicial diligence. This is obviously very biased. They're biased towards the banks. They're biased for the fact that I sued the Canadian judges or organized a big part of it, and they are coming after me for revenge because they're just biased because we actually sued them. Now, lack of judicial diligence is obvious. I'm not getting my due process. Now, here's another one: inconsistent application. If some judges use memorandum decisions excessively while others rarely use them, it could lead to inconsistency in judicial practices, which might undermine the fairness and predictability of the legal system. So again, the fairness and predictability of the legal system is that if something like this comes up and they have a problem with you, they do not just go make memorandums up and don't even invite you and put orders against you. What they do is they would send out a statement of claim. You'd have 20 days to respond with your defense. Then all the evidence would be shown to each other, and you'd get to rebut each other's evidence. None of this is here. This is an absolute abusive process, and it must be stopped. Even ChatGPT agree with us. Have a great day.
As you can see, the memorandum process is being completely abused, which is called abusive process. The culprit is Judge Neilson and 3 unethical Alberta bank lawyers. Now, it gets worse, but more interesting. On May 30th, 2024, just 6 days after Judge Neilson created the bogus order, Capital One lawyer Keith Marlowe, who requested to have a statement of claim struck regarding Kerslake versus Capital One. due to it having OPCA traits. Judge Neilson denied the request because he said it did not have OPCA traits, but in the memorandum order, he says the exact opposite about the exact same court file, contradicting himself. We have the documents with voiceover where he clearly states it is not OPCA, but before we do that, let's explain what OPCA refers to. OPCA stands for Organized Pseudo-Legal Commercial Arguments. This is basically the name the courts give arguments regarding did the bank really lend you money due to the fact they are printing money out of thin air. OPCA arguments can use phrases such as we are children of God and this is why we do not have to pay back our debt, or money for nothing because the bank creates money out of thin air. For their own unethical reasons, Judge Neilson and the 3 unethical bank lawyers are trying to lump the whole Canadian private mortgage market into this group to discredit and slander a whole industry, which is absolutely ridiculous. Private lenders have been asking for proof of ownership of the debt before the banks even existed. This is a fundamental part of any transaction, making sure you're handing the money to the rightful owner of the asset. And in this case, the asset happens to be a debt. The cases that are mentioned in the bogus orders and memorandum is what they're trying to categorize as OPCA are very simple, straightforward, conventional cases. These cases basically follow this scenario. A Canadian is overwhelmed with debt due to the compound interest trap the banks lure all Canadians into. So the Canadian heads out into the capitalist marketplace looking for a better interest rate for him and his family. He jumps on the internet and responds to an ad a private lender placed. The Canadian borrower and private lender communicate and decide to enter into a loan contract. Now, contract law exists, and our civil courts are contract law courts. So as long as the contract is not breached, then there is no foul. Part of the contract is that they will need verifiable proof the debt was not sold, which only makes sense considering it is a well-known fact banks sell debt via a process called securitization. This would be considered a reasonable request considering they sell debt via securitization, and it states clearly in all their contracts that they can sell the debt without informing you under the assignment clause. Check it out in your own contracts. To give you some recent history regarding the bank, back in 2008 when the world finance crash happened, the banks admitted the reason it happened was because they were selling debts irresponsibly to the world market. They even made a Hollywood movie about it called The Big Short. Taking this into consideration, private lenders who have been around for a while, who never did ask the bank for proof of ownership in the past, started to exercise their rights to do so in partnership with the borrower when consolidating Canadian debts. You see, debt is an asset that can be bought and sold. So a perfect example is when purchasing a car. Let's say you were buying a car from me. And I said, it's time to give me the money. And you said, okay, but can I see proof of ownership of the vehicle before giving you the money? And I said, well, I don't have proof of ownership on me right now, but give me the money anyways. Obviously, you would be a fool to do so. The same premise holds true in the mortgage industry. If the bank sold the debt and then the private lender pays the bank out, the bank just got paid twice. Keep in mind, I've been in the finance industry for over 30 years. This is why I know so much about this stuff. But don't take my word for it. We also chat GTP'd ownership of the debt in this situation. Take a look at this.
Okay guys, so we chat GPT'd is requesting proof of ownership of a debt before paying it, an OPCA scheme in Canada. Its response: no, requesting proof of ownership of a debt before paying it is not an OPCA scheme in Canada. In fact, it is a legitimate and common practice. When a creditor or debtor collector claims that you owe money, you have the right to ask for validation and verification of the debt. This includes requesting documentation that proves the debt is valid and that the creditor or collector has the right to collect it. This process is part of your consumer rights and helps ensure that you are not being wrongfully charged or defrauded. OPCA schemes, on the other hand, involve the use of pseudo-legal arguments and tactics that are not recognized by the law, often with the intention of evading legal obligations or defrauding others. Examples including claiming that laws do not apply to individuals, using false documents, or presenting nonsensical legal arguments in court. Asking for proof of debt is a straightforward and legal recognized step in managing your financial responsibilities and ensuring accuracy in debt collection. So guys, that is very straightforward. The first thing it says is no, requesting proof of ownership of a debt before paying it is not an OPCA scheme in Canada. Let's just leave it there. This is an absolutely bogus order.